So this week we were supposed to be in trial, but unfortunately the case settled at the last second, Friday afternoon before a Monday trial. So all the work we did preparing for the case, we didn't need to do. So rather than let all that hard work preparing to try the case go to waste, figured I'd create a couple of videos to help out young lawyers who maybe haven't tried a case before, figure out how they want to prepare. So this isn't the only way to do it, but it's the way I do it. So trial tip number one. For me, it all starts with what I call the map of the facts. As I'm reading the depositions, in this case, I really hadn't worked on the case all that much on the liability side before preparing for trial. It was Zach's case. He had worked on it the whole time. So I was reading all the depositions and going through everything and trying to create a list of bad facts, neutral facts, and good facts. And I put them on here. Now, this isn't something that I came up with. I can't take credit for it. I learned this from Mark Lanier many years ago. I've used it several times. It works great for me. And the way it works is you list out your good and your neutral and your bad facts, only the important ones, the ones that the jury's going to decide the case on. You put them on here. And then as you go through your trial preparation, you try to figure out how do you take your bad facts and either neutralize them or spin them and make them a good fact for you. You can't do it with every fact, but sometimes you can. Let me give you an example. So in this case that we were just preparing, our client was going 15 miles an hour over the speed limit near a school zone. She was doing 39 and a 25. It wasn't in a school zone, but it was near a school zone. Now, 15 miles an hour over the speed limit. That's a bad fact. There's nothing we can do about that. But near a school zone, that's something that would be more bad, for lack of a better word, and we would try to keep it out. So our plan is to keep that out with a motion in limine. If that doesn't work, we have to have an argument prepared to handle that. And so what I came up with was, if we have to make it a bad fact for us, let's make it a bad fact for everybody, and hopefully that neutralizes it out. So how are we going to do that? Well, in this case, the defendant didn't see our client's vehicle before making the left turn and getting in the crash. So if he didn't see a pretty significant SUV coming down the road, he didn't see children, he didn't see joggers, he wasn't looking where he needed to be looking in order to make his turn safely. So I start with a map of the facts, and I use this as my kind of like my go-to throughout the trial. It keeps us on track, keeps us focusing on the facts that are going to win the case for us and the arguments that are going to win the case for us. So that's tip number one. Tip number two is something else I'm borrowing from Mark Lanier. It's the folder system, the Redweld system. So I learned this at one of his seminars, and I think it's great. Every witness that I'm going to handle in the case, I create a Redweld for. Some of them will be, kind of thin, and some of them will be kind of thick. Some of them will get multiple Redwelds. But the idea is, in here, you have your outline for what you're going to ask the witness, your questions. You have all the exhibits that you're possibly going to use with the witness. Each one of them gets a folder so that it's organized. You have your marked up copy of the defendant's depo transcript with all your notes in it. And you have everything that you could need. For example, in this case, I was going to use the defendant's answers to interrogatories with him. So here are the answers to interrogatories. I've got multiple copies here. This is my copy, highlighted study copy with my notes on it. I know when I go to cross-examine the defendant, I've got all the points I want to hit on these answer to interrogatories highlighted, underlined with notes in the margin. Now, I'm not going to put this copy in front of the jury. I've got a blank copy here that we can use with the witness. We've got one for defense counsel, and we have extras for good luck, just in case you need them. So that is the folder system. I also keep everything you're going to use with the witness in here, including photographs, anything you're going to do, keep it in the folder system. Trial preparation tip number 3. I like to write out like a cross-examination in my mind. And the way I do it is walk through all the questions that I'm going to ask. And then when there's a question where the defendant could go two ways on it, I write out a path or a plan of attack for each way. So if a question gets answered and the answer is yes, here are the possible questions that I'm going to ask and the method of attacking that answer. If the same question, if the witness doesn't answer yes, if they answer no, I've got a separate plan of attack for how I'm going to handle that with my arguments and everything. So as I write out my questions, I plan for each way the question or the answer could break. And then I create my impeachment points. This is sort of like a deposition outline, but what it is I go through the deposition of the witness, and rather than write out the question and answer that I'm going to use or just generally summarize the transcript, what I do is I find questions that are good. They're tight questions with clear answers on important facts that I will need if the witness strays from his deposition testimony at trial. So what I do is I write out a brief summary incorporating the important words of each answer here. So for example, here's a good one. I made a left turn when I didn't have a clear view of approaching lanes. Now the question was a little more complicated than that. The answer was a little bit more of an explanation, but that's the principle that I would need for cross-examination. Now, am I actually going to ask the witness about this? No. What I'm going to do is, as I'm asking questions, if the witness strays from their answer, I know I can go on here onto my impeachment points. I'll have it in the Redweld, pull it out, and I will know page and line. That's how it's set up. One sentence, kind of in shorthand, with page and line of everything I'm going to need to cross-examine that witness. So then I can start my impeachment. I can confirm the testimony that's contradictory, can get my deposition transcript out while I'm confirming. Then I'm going to credit the testimony, remember, build it up, and then confront. And by the time I get to confront, I will have my page and line ready to go, and my impeachment points, which helps me get there so fast. First trial I ever did, I was working at a law firm at the time, and the way they taught to prepare for that kind of thing was tabs. So this is my deposition binder. This is what I read for trial to get ready. Tab it all up. Problem is, when you go to cross-examine with tabs, now you have to flip through all this to try to find which tab is the one that I need. It's better, and then you have to read the testimony. It's too complicated, it takes too long, and when I tried to do it using this method, you feel like you lose a little bit of steam.